Good afternoon. My name is Agnes Chong, and I'm an assistant professor here at CUHK Law and chair of the Environmental, Energy and Climate Law Cluster at our Centre of Comparative and Transnational Law. We are delighted to welcome Dr. Erin O'Donnell, who is a senior research fellow and senior lecturer at the University of Melbourne Law School. Dr. O'Donnell is a water law and policy expert and is recognized internationally for her research in the field of legal rights for rivers. Her work explores the challenges and opportunities these new rights create for protecting the multiple social, cultural, and natural values of rivers. Dr. O'Donnell's work is informed by comparative analyses across Australia, Aotearoa, New Zealand, the US, Bangladesh, India, Colombia, and Chile. She has also worked for the World Bank examining water markets and their role in water security and sustainable development. Dr. O'Donnell's research is genuinely groundbreaking in the field of environmental law, and it is a great honor to welcome her to speak to us. Thank you, Dr. O'Donnell, for taking the time out of your very busy schedule to give us this seminar today. So Dr. O'Donnell will speak for around 40 minutes, after which we will spend the remaining time for Q&A. So please send your questions to me in advance via the chat box. And without further ado, I will hand over to Dr. O'Donnell.
Thank you so much, Agnes, and thank you to everyone for having me here today. It's such a pleasure to be part of you and to watch the incredible kind of lead-in video that we had there of all of the other amazing presentations that this university has played host to. It's a real privilege to be the latest in the line of such an exciting conversation that you've been having on so many legal issues. I am going to hopefully be able to share my screen. Let me just work through that. Now, hopefully, is that coming up as, aha, that's probably better. That's, yeah, Agnes is nodding at me, excellent. So thank you so much, everybody. I am going to be talking to you today about enforcing the rights of river persons. And I think the key question here is actually to ask ourselves, what does force and effect actually look like when we have this conversation about river persons? Rivers have been recognised in lots of different ways around the world. It's an idea that has extraordinary resonance and is really challenging to our legal frameworks. And so asking ourselves, not just how do we give it force and effect, but what do we understand by force and effect? What are the outcomes that we're actually trying to achieve with this exciting and transformative legal reform? I'm going to begin this presentation with an acknowledgement of country. In Australia, this is particularly important because Australia does not have a treaty with any Indigenous peoples in Australia. So basically, the British invaded 230 years ago, and since then we've been trying to pretend that it's been a legal occupation. The sovereign nations of Indigenous peoples continue to challenge that. So I am speaking today on the sovereign lands of the Wurundjeri people. I pay my respects to their elders, past and present, and I acknowledge that they have never ceded their rights and obligations to care for their lands and waters. This is a really important place to begin this conversation because we're talking about rivers, we're talking about our obligations to rivers and our relationships with rivers. And again, in the context of Australia, as in many parts of the world, it's important to begin that journey with the people that know the river best. So one of the other hats that I wear at the moment is that I'm a member of the Birrarung Council. And you can see this beautiful photo here, as well as the one behind me on my screen. These are images of the Birrarung, the Yarra River, the river that flows from the mountains to the sea right through the heart of the city of Melbourne. This river is now recognised in law as a living entity, and it's Australia's first and so far only river to be having that status in the law of the settler state. I'd also like to read a short part of a poem written by Amberlyn Quaimulina, an Indigenous woman of the Palaku people in Western Australia. She says, "You are on Indigenous lands, swimming in Indigenous waters, looking up at Indigenous skies." And this is true regardless of which country we are in. Everybody is Indigenous to somewhere, as Uncle Dave Wandon of the Wurundjeri people tells me. And it's an important reminder to all of us to reconnect with our own ancestral sense of belonging and how we come to a particular place. So getting back to this question then of what happens when we give rivers legal rights and the extraordinary diversification that we've seen in river persons around the world, I thought we could begin by just acknowledging the trajectory of reform that has happened over the past almost 20 years, no, over 20 years. So we're starting to see an acceleration in the way that rights of nature has been recognised. I think almost any conversation about the rights of nature in a legal setting tends to begin with the seminal paper from Christopher Stone back in 1972. But the idea languished on the fringes of environmental law for a long time. So even in the sort of early 2000s, people were still able to write papers. I think there was a 40th anniversary edition of his idea at around 2012, and people were still writing papers as though it was a largely theoretical concept and construct, and as though it was never really going to be part of mainstream environmental law. And you can see that around the world, this situation has been gradually changing and is now gathering extraordinary momentum. So going back to 2006, when the first local laws to recognise the rights of nature started to be passed in the United States, the big turning point was probably 2008, when Ecuador reformed its constitution to recognise the rights of nature. Again, though, it was a very slow pace of continued reform and development until about 2017. Then rivers became the focus of the rights of nature, and we started to see river persons emerging in laws, and those are the ones that I've bolded in this timeline. And since then, it's just continued to gather pace. If you want to get a sense of the global reach of rights of nature legislation and other forms of law, have a look at the Eco-Jurisprudence Monitor website. This has started to map around the world, where you can start to see rights of nature laws and case laws and treaties and other agreement making, where that's starting to appear around the world. And as I said, it's diverse and it's global. So this is definitely a movement whose time has come. As I said, 2017 was the banner year when it comes to rivers being recognised as persons in the law. And 3 rivers really led the charge in that space. So in March 2017, the Wanganui River in Aotearoa, New Zealand, and the Gundra and Yamuna rivers in India received legal personhood status. Later that year, in July, the Rio Trato in Colombia received legal subject status, and I'll talk a bit about the difference between those in a second. The Rio Trato actually predated the other 2 in its judgment, but which was passed in 2016, but it didn't actually become public until 2017. So suddenly, around the world, people are starting to ask the questions, what does it mean for rivers to gain personhood status? But in addition to this kind of uncertainty, there was a lot of people saying, aha, I can see this taking place in other parts of the world. I want to bring it into my own legal frameworks. And so seeing these successful cases, even though the Gundra and Yamuna rivers have now been stayed pending an appeal, this range of successful cases around the world inspired many others to continue this trend. So I spoke to you about the Birrarung in Melbourne. This legislation was also passed in 2017 to recognise the river as a living entity. And it explicitly looked at other models around the world to see how other countries are engaging with this and what the benefits are of recognising rivers in this way. And as you saw from the previous slide, this has been followed by cases in Bangladesh, Mexico, ongoing cases in the USA, from both tribes and from the settler state law and legal frameworks, and in Canada as well. So it's a truly global movement. In this presentation, I'm going to be really talking to 4 specific questions. And it's the overarching theme of, what does it mean to give force and effect to river rights? What does it mean for river persons to be enforceable, to have enforceable rights? So the first question really is then, well, what types of river person actually have legally enforceable rights? Because not all of them do. It doesn't mean that the others aren't worth having. They bring their own benefits, but this space is one of experimentation. And so it's really important to understand what kind of river person you're talking about. And also, when you're thinking about enacting these kinds of reforms, to think about what problem you're trying to solve in creating a specific type of legal person or river person. The second question then is, well, which rights do those rivers actually have if they're recognised in law as a river person of some kind? And there's a difference between the rights and powers that they might have in law as legal entities and the substantive rights that they have in water management. There's often a significant disconnect between water law and the laws that are recognising river persons. So we'll talk a little bit about that as well. Thirdly, this question of who can speak for the rivers. So if their rights are infringed, whose job is it to stand up and enforce those rights? Whose job is it to take action on behalf of the rivers? And how empowered are they to actually take that action? And then fourthly, ultimately, force and effect is about effect, right? It's about the impacts and outcomes. So what kinds of impacts and outcomes are we actually seeing achieved on the ground? This is still very early in this process of recognising the rights of rivers. So there are probably fairly limited impacts so far, but we can start to point to some trends, including some kind of unexpected outcomes. So the first question then, what type of river person are we actually talking about? This is quite a confused space. It's partly confused because, as you'll see in a moment, many of these ideas are actually bundled together in legislation and in case law. Rivers tend to be multiple kinds of legal person. But there are significant differences between each of these types of river person, and that plays into the ability they have to solve the problem that a particular reform is seeking to achieve. So if we work through them, at the top there we have the legal person. In common law countries, this is probably the best known type of legal person or legal entity. It includes human beings, although we are sometimes termed natural person, but we do have the rights and powers of a legal person. It is more commonly understood to include things like corporations, legal fictions that have the ability to bear rights and powers in law. There's been an extraordinary amount written on the idea of legal personhood, who can have it, what it can append to, what does it really mean? Is it a statement? Is it a moral statement? Is it linked just to these abilities to bear rights and powers? Is it dependent on the ability of the legal person to exert their own agency? Do they need a certain level of mental capacity in order to go alongside their legal personhood status? This has been a debate that's been going on around the world for well over a century. Philosophically, it's been going on for a lot longer than that. We're starting to see some common threads emerge around legal personhood. So in common law countries, a legal person is a bundle of rights and powers. There's a great work that came out from CUHK in 2019 that starts to help understand maybe the difference between passive legal personhood and active legal personhood. So he starts to create different models around this idea of who has the required agency to exert specific rights and powers in that context. So we have this bundle of rights, but what it tends to include are things like legal standing, the right to go to court, to sue and to be sued, the right to enter into and enforce contracts, the right to own property. These are the kind of inherent legal rights that go along with the legal person. And we can assume that legal persons will have those kinds of rights. One of the really exciting spaces that I've become more involved in over the last couple of years has been the work in the field of disability rights. So the Convention on the Rights for the People with Disabilities now formally recognises all people with disabilities as legal persons. So this does away with the argument that you must have a certain level of agency or mental capacity in order to be a full legal person. You might require a guardian or someone to act on your behalf or to express your will and preference, but you don't necessarily need an inherent level of mental capacity in order to have full personhood. And that's incredibly important when it comes to protecting the human rights of people with disabilities. So that's the legal person. Incredibly important in a common law setting if you want to go to court, if you want to have those legally enforceable rights that you can then rely on, if you are seeking to actually engage in those kinds of legal relations. So you want to own property rights, or you want to enter into contracts, or you want to go to court and actually enforce your rights, uphold them if somebody is stepping into them. The subject of rights is a very similar thing. This is an idea that tends to occur more in civil law jurisdictions. The subject, very similar to the legal person, but the flexibility is where it shifts. So a subject of rights requires the court or the legislature to articulate what those rights are. So there's not this assumption that they will have certain rights, such as the ability to hold property, but rather they will have the rights that they are given. So this can be another really powerful way of shifting the conversation away from these quite human rights around property and contract into more substantive rights that rivers might find particularly useful. And I'll talk to you a little bit about an example in a second. Again, this is an idea that really comes from civil law jurisdictions. So we've got some jurisdictional themes starting to emerge. We've also got these kind of enforceability questions starting to come through as well. So legal person and legal subject are both incredibly legally powerful forms of river persons. Then we have the idea of the living person. This is a really challenging one. We don't see it too often, but it does crop up in a few cases, particularly from South Asia. The idea of a living person is really challenging to law because so far, the only living person that the law really understands as a person is a human person, right? It's very similar to the idea of a natural person. So if a river is recognized as a living person, does it start to take on the attributes of a human person? Does it have access to human rights? Does it start to play a role in things like criminal law? So Ganga and Yamuna rivers were both recognized as living persons. On that recognition, activists then filed a police report saying that the Yamuna River must have been the victim of a homicide because the court declared that it was a living person. The river was so polluted that the river was considered to be dead. And the activists decided, well, if it was a living person and it's now dead, somebody must have killed it. So this kind of legal creativity is a response to this potential blurring of the lines between these different forms of personhood. Now, I don't really take a position on whether or not that's appropriate, but it does, again, point to this need to say, well, what kind of rights and powers do we actually want the river to have? Do we want to treat the river as though it is a human person? If we do, then maybe a living person idea is actually, that's quite powerful, quite useful. But you can see all kinds of circumstances in which it's probably not okay to treat the river as a human person, because then we start to think about how do we hold the actions of the river to account as well. And that was another really big problem in the Ganga and Yamuna cases, because the guardians that the court appointed for those rivers were very reluctant to take on that role and responsibility because the court indicated that they were in loco parentis. They were standing in the shoes of parents when it came to the rivers that the court constructed as living persons and also minors. So the liability that the guardians might be taking on could potentially be larger than it would have otherwise been because they were acting as parents for the child rivers. So again, let's think about the problem we're trying to solve and let's make sure that the type of legal person is actually relevant to that problem. Right down the bottom here, last one is the living being or living entity. This is not a very legally powerful term. It doesn't bring with it any assumed rights or powers. It doesn't even necessarily bring the ability to bear rights and powers or duties. So the living entity is much more about the relationship between people and the river. So it's formalizing that relationship. It's elevating the river beyond a mere object over which humans have complete domination. So if we think about this in the context of water law says water is a resource. Water is a resource that we can extract from, that we can manage, that we have control over, that we can use. Recognizing rivers as living beings or living entities is a really big challenge to that assumption that water is nothing more than a resource. And it brings us into relation with the river. So it's probably pretty useless if you desperately need to go to court. If you need to go to court and enforce the river person's rights and rely on them in court, then recognizing the river as a living entity will be of very little use to you. But if what you're really aiming for is a long-term transformation of the relationship between people and the river, then recognizing the river as a living entity can be a very powerful way to begin that transformation without getting bogged down in the question of legal rights and powers. And I'll talk a bit more about the potential kind of backlash or paradox that can emerge in that setting a bit later. So again, these 4 different ways of recognizing river persons are distinct. They are relevant to the problem that you're trying to solve, and they each have different forms of legal rights and powers and different levels of legal enforceability. So understanding which is really important. And of course, it gets very complicated because when we look around the world, rivers are often combinations of those things. So if we start at the top here, I won't go through all of these because I think we'll run out of time, but if we look at the Rio Atrato in Colombia, civil law jurisdiction, the Rio Atrato was recognized as an entidad sujeto de derechos, which in my very bad Spanish is an entity that is the subject of rights. So this is a legal subject concept. And you can see there that the Constitutional Court, in recognizing the river as the subject of rights, then had to enumerate what those rights were. So they're the rights of protection, conservation, maintenance, and restoration. So you can see immediately that this river does not have the right to own property. That starts to become a problem when we think about the enforceability of its rights and the kinds of substantive rights it might need a bit later on. So the court gave it these legal powers, but then limited. On the other hand, these are the kinds of rights that probably matter most to the river. Protection, conservation, maintenance, and restoration, they are all geared around the needs of the river. So they're quite tailored. If we look at the Wanganui River, Te Awatupua in Aotearoa, New Zealand, this is a combination. It is both an indivisible and living whole. This is in the legislation. It is also a legal person. So it's starting to bring together multiple forms of legal personhood or legal entity into the one entity. Gunda and Yamuna rivers, we've already talked a bit about. This is pretty much everything. And the judges in this series of Indian cases tend to use this kind of combination approach where they talk about juristic legal persons, living entities, legal persons, and living persons. Sometimes it's moral person. They bring all of these ideas together and basically package up the river persons or nature's person to be all of these things all at once. I haven't seen a lot coming out of India yet that actually starts to unpack that and try and make sense of how you actually make that workable. When we look at Australia, as I flagged at the beginning, we've got the Birrarung, the Yarra River in Victoria, so far, Australia's first and only, that has been recognised in the law of the settler state. The Birrarung is one living and natural entity. So it's a living entity, it's not a legal person. It does not have those rights and powers. It doesn't have the capacity to bear those rights and powers. Similarly, but a little different, is the Mudawarra Fitzroy River. And if anybody's been getting any of the Australian news, the Mudawarra Fitzroy River is in northwestern Western Australia. It's been the site of absolutely horrific flooding over the last couple of months. The river is definitely exerting itself and its presence. The Mudawarra Fitzroy River was recognised in 2016 by the traditional owners, the Indigenous peoples of the river. There are multiple nations that make their home along the river and have done so for tens of thousands of years. And they came together to say that the Fitzroy River is a living ancestral being with a right to life. So this is the way that their laws recognise the river. So again, we've got living being, but we're starting to bring in the idea of rights that are attaching to that living being. But this has not been reflected in settler state legislation in Australia. So there's been no corresponding uptake of this idea by the state of Western Australia. And so that means that although this law might be binding for traditional owners, it has no impact on the way that the state manages the water or engages with the river. No impact on a legal sense. Of course, it has an impact politically, but that's a slightly different question. Further to this idea of enforceability then, is not only the nature of the river person, but the legal mechanism by which the reform is achieved. And we can start to see the way this, I guess, makes a difference when it comes to enforceability. It's a trade-off oftentimes between the ease of creating it. So local laws, for instance, are much easier to reform and change generally than seeking change at the constitutional level, right? This is incredibly difficult, as we've just seen in the case of Chile and their failed constitutional reform last year, which would have recognised the rights of nature. So for so many reasons, that was fairly devastating when that didn't go through. But enforceability then becomes the trade-off. So if you look at the local law, it can be very easy to change. One of the great examples here that demonstrates this kind of trade-off is the Lake Erie Bill of Rights that was passed in 2019 by the city of Toledo in Ohio in the United States. And this sought to recognise the rights of all of Lake Erie. So Lake Erie is an enormous lake. This was a small town on one side of that lake. Lake Erie crosses national boundaries, it crosses state boundaries, it crosses local boundaries. So there was already a jurisdictional issue around the ability of this tiny town to declare rights over the whole lake. They amended their local law, but the very next day after that law came into effect, it was challenged by a corporation called Drew's Farm, who felt that the rights of the lake were a problem for them. They might be a weapon basically pointed at them that might require them to change their farming practices. So they challenged the constitutionality of this law. And the court in that instance found two levels of problems. Firstly, they said it's too vague. Like, we don't understand what you mean by the rights of the lake, and we don't understand what it would mean to identify somebody being in breach of those rights. So that was the grounds on which it was struck down, and that was the argument that was put forward by Drew's Farm, was about vagary. But the other ground the court also said was, look, even if you didn't succeed on vagary, you would still have been successful on constitutional grounds, because this is a local law that purports to create rights that people can then rely on to challenge state or federal laws. And so, of course, if a local law is inconsistent with a state or federal law, it is invalid to the extent of that inconsistency. So local laws are easy to change, but in terms of enforceability, you can't rely on them necessarily to get the kinds of outcomes that you're looking for. As we've talked about, constitutions can be much more difficult to reform, but they're obviously going to be much more powerful. Statute and case law are often in the middle there. The other thing to keep in mind here, when we're talking about river persons and the kinds of problems that we're trying to solve, it's often about specificity and relationship and connection to place. So it's about the relationship between people and a specific river. So at any level of law reform, you can reflect that specificity, but it's important to keep it in mind, because it gets more and more challenging, of course, as you move further up into more overarching laws. And so, for instance, at the constitutional level, you're unlikely to see a constitution that talks about the rights of a specific river, but what it can do is set up the ability of a constitutional court, like in the case of the Rio Atrato, to find that the relationship between people and the river is so important that in upholding the people's constitutional rights, the river must have rights as well. That was the most effective way to protect the rights of the people, was to recognise the rights of the river. So even at that overarching level, where rights tend to be written at fairly abstract scales, that connection and specificity can emerge through the interpretation of those rights. So again, when we look around the world, we can see that there's enormous diversity in the legal mechanisms that are being used to progress the rights of rivers. So we've talked obviously about the Constitutional Court. The Wanganui River in Aotearoa, New Zealand is a really interesting one, because it's a founding document issue which places it at the level of the Constitution, and it's then being given effect through national legislation. So the Wanganui River rights really emerged from a treaty dispute settlement based on the Treaty of Waitangi. And this is New Zealand's founding document. We've had local law in the US. There's also been tribal law in the US. So we talked a little bit about the Matawarra River as an example of Indigenous laws in Australia. In the US, of course, they have historical agreements like treaties and reservations in which tribes can pass their own laws that have force and effect within their spatial jurisdiction, which is often the reservation. So it's more than what's happened in Australia, where the settler state of Australia doesn't necessarily recognise the ability of Indigenous nations to pass their own laws. And of course, we've always had state legislation and high courts, state high courts, lots of diversity really throughout this. One of the interesting things I think to keep an eye on is not just the enforceability question, but also the jurisdictional question. So again, what is the problem you're trying to solve in recognising the river as a river person? And are you targeting your law reform at the right jurisdiction and the right legal mechanism to enable it to have force and effect? Moving on then to this question of what substantive rights do rivers have? This is a really challenging one because so far there has not been a strong connection between water law and the rights of rivers. So all of those legal mechanisms that we were just talking about tend to happen in isolation from water law. Now, this is not uncommon, right? Water law tends to be its own thing. It's usually a very technocratic, very bureaucratic space in which law is promulgated and implemented. It's often quite disconnected from other larger law reforms or legal conversations. And I say this as a water lawyer because it's often really difficult to get people to pay attention to what's happening in water law because it is so much its own kind of isolated area. But it's a really big problem when we're trying to talk about the connection between river persons and the way in which water is managed. So when we look around the world, not a single river, not one, that has been recognised as having any kind of personhood status, so legal person, legal subject, living person, or living entity, not one has rights to water. So the water flowing between their banks, the water that is the essence of the definition of river, they don't have any rights to that. This is a pretty major problem. So that's problem number one. There has been an attempt to try and start rectifying this situation by recognising the river as having the right to flow. So the Mutaheku River in Canada, which was recognised as a river person in 2021, includes the right to flow. But this was a local law. It was an agreement and a kind of dual resolution between a local government and a First Nations government. So it's already like it's a local law. So it's got that challenge. It's not connected to their water law statutes. So it doesn't necessarily reform those water law statutes. It doesn't integrate with them. It doesn't necessarily alter the allocation of water rights. So even when we're starting to recognise the right to flow, we're still not seeing that come through in terms of the way that water is managed. The situation is slightly different when we think about water management, but it's not substantively different, disappointingly. So water management, we're starting to see the new institutions emerge that have either a direct role, so specifically on the Wanganui River, Te Aotearoa, we're seeing new institutions that do have responsibilities for developing strategies to guide the future management of the river and the catchment around the river. But it's still a collaborative exercise. The voice of the river becomes merely one voice in that kind of stakeholder arrangement by which the river and its catchment are managed. So the ability of the river itself to exert much power and influence in the way that water is managed is extremely limited. In some cases, so if we look at the Turag and the other rivers in Bangladesh, one of the directions that the court passed in the original case was to say that the executive government needed to pass new legislation to give the River Guardian, the National River Protection Commission, the powers it needed to actually be an effective guardian. Now that was appealed. The appellate division decided that, yep, it's not our job to give directions to the executive. We can merely express opinions. So that direction became kind of an advice from the court rather than a requirement. So again, we're waiting to see whether the Bangladesh government actually passes the legislation that would enable this guardian to start playing the kinds of roles and taking on the rights and powers that it needs to give force and effect to the river's rights. So we can recognise extraordinarily powerful in law versions of river persons. But if we're not connecting those powers into water law, they have very limited ability to challenge the way that water is allocated and used. In many parts of the world, water is already over-allocated. You've got a quantity problem, you've also got a quality problem. So quality then plays into the way that water is managed and that the catchment is managed. If the river person has no ability to control the flow of water between its banks, to control the quality of water that it depends on, its substantive rights and the enforceability of those substantive rights are really quite minimal. So that's probably the big take-home message from this presentation, is that we need much better integration between the law reform that is recognising river persons and the laws in which water is managed and catchments are cared for. Next, there's got this question of who speaks for the rivers. So whose job is it to actually go out and enforce whatever rights they actually do have? And again, this question of what problem are you trying to solve in creating these river guardians? What kinds of rights do they have? What sorts of enforcement mechanisms do you expect them to be using? So the Rio Trato in Colombia was a really interesting one, because the original court decision envisaged a guardian that was made up of one representative from the local communities working alongside the Ministry for Environment. So they recognised that you needed communities to have a voice into a government process, but they saw it as a bit of a 50-50. The communities along the river immediately said, well, you know, that's an idea. What we really need is to make sure that there's gender representation, because women and men have different relationships with water. And there are 7 main communities, all of whom have different relationships with the river. We all need voices in this guardianship arrangement. So it immediately diversified to reflect the communities. The Rio Trato was a really interesting case because of that connection between the rights of the people and the rights of the river. So the rights of the river were defined by the court as biocultural rights. And so again, that interdependence required that diversity in the representation. If we look at, say, another example, the Birrarung Council. So I'm a member of the Birrarung Council. This is a statutory committee. It's appointed by the Minister for Water. We act as the voice of the river. So we speak for the river, but the river's a living entity. It doesn't have any legal powers. It has very limited ability to influence the way that the water is managed or the catchment is managed. So when it comes to enforceability, our job is more about transforming the relationship between people and the river and creating a space for this new relationship to grow and develop, so that the people who live along and love the river and whose actions affect the river recognize that the river is this living being and that they are in a relationship with it. So we are more of a conduit in that relationship space, more of a kind of a conscience, I think, in the way that policy is made. So again, it's thinking about what does enforceability look like, and therefore what does speaking for the river actually need to include? Is it the ability to insert yourself into a policy conversation? Because then a voice for a living entity could be quite effective. Is it the ability to start actually acquiring rights to water? In which case you're going to need the ability to hold property and enter into contracts and enforce those contracts. Is it the ability to actually go to court? Do you need your guardian to stand up and take action on your behalf? The very earliest case of a river in which this happened, which I'll talk about a little bit as part of the impacts and outcomes, there were no dedicated guardians. So the very first thing they had to do was to find people who would take action on behalf of the river. So this was in Ecuador. The Ecuadorian constitution says that any citizen can speak on the behalf of nature. Nature has rights. Anyone is empowered to enforce those rights. When it's everyone's job, it can also sometimes be no one's job. It's also incredibly expensive, as we know, to run a legal case. So you need somebody who's actually equipped to do that and equipped to follow through when they might win the first victory, but then they might need to come back and seek enforcement provisions. So knowing who your guardians are and what actions you expect them to take is a really big part of this force and effect equation. So when we think about the impacts and outcomes, what has been achieved by these new river persons and in the recognition of those river persons? Agnes, also please let me know if I'm starting to run over time. Thanks. So I was just talking there about the Rio Vilcabamba in Ecuador. In this case, this was the very first example of river rights being upheld by the court. Getting there was an extraordinary effort. So 2008, Ecuador amended its constitution. This case was heard in 2010. There had been a road development alongside the Rio Vilcabamba in which the movement of gravel and the construction of the road had basically pushed a whole lot of muck and a whole lot of garbage into the river, causing pollution problems, also affecting the riverbed, causing all kinds of issues for the river. So the local community wanted to rely on these new rights under the Constitution. In order to do that, they had to basically go out and educate a whole bunch of judges to see if they could get them to even open their minds to the idea that this is a case that you could now successfully bring to court, let alone win. So this took multiple conversations with multiple judges before they found someone who could get their heads around the idea that this is something that, could be brought before a court. In that case, the rights of the river were actually upheld. So it was a victory of sorts, because of course, in doing so, the court considered not only the rights of the river, but also the rights of the developer. So if you've paid any attention to environmental law over the past, 50 years or so, it almost always ends up in this balancing equation. It's, the impacts to the environment versus the social and economic benefits of a particular project, or in this case, the rights of the environment versus the rights of the developer. And so you get stuck in this trade-off. So it was, I think for me, it was really personally frustrating to see that that's exactly where the court ended up, even with the new rights of the river. So ended up in this balancing equation, recognized the rights of the river, but also said, look, the developer did have the right to build the road. They didn't have the right to cause the damage to the river. So they had to go and remediate that damage. So of course, there's a big difference between remediation and not taking the action at all. And trying to make something right after you've already had an impact is always going to be second best, often significantly so. In this case, it took about another 8 years before any remediation works actually got started. And they had to go back to court multiple times to get those enforcement proceedings. So again, the ability of that local community to work with NGOs, to keep going back to the court, for the court to eventually actually hold the developer liable and for those damages to start to be made good. It's been a long, slow process. But in Ecuador, the Rio Vilcabamba was the first case. It was not the last case. There's been a significant growth. For the first 10 years or so, it was relatively slow. But since 2018, with new members on the Constitutional Court in Ecuador, they have called in a number of cases to try and start providing more rigor around what rights of nature actually mean in Ecuador. And what they're starting to show with a series of cases is that these rights are not just in this balancing act with the rights of developers. They're not just part and parcel of the existing environmental protection legislation. So you can, as a developer, comply with all of the requirements under the existing legislation and get all of your approvals. If somebody takes you to the Constitutional Court, they can still say, actually, in this instance, you have not done enough to comply with the protection of the rights of nature. So they're starting to develop this difference between what the rights of nature give you and what's actually sort of in the ordinary environmental protection legislation. So that's a really exciting space to watch. And again, we've seen that acceleration and momentum being built over the last 4 years. So I think, yeah, Ecuador is the space to watch to see this become really embedded within the kind of day-to-day business of environmental law. The Wanganui River is also a case where you can start to see some outcomes, but almost from the opposite perspective, right? The Wanganui River is a legal person. Te Aotearoa is a legal person, but it's also a living and indivisible whole. The personhood of Te Aotearoa came out of that treaty dispute settlement. Neither party intended to create legal personality for the Wanganui River for the purposes of granting legal personality to the Wanganui River. It was basically a circuit breaker in the negotiations because Maori, the Wanganui iwi, claimed that under the treaty, the river was taonga, was treasure, and therefore it belonged to Maori. They said, we've never ceded that, and our treaty protects our rights to taonga. Of course, the settler state of New Zealand was very reluctant to hand over the ownership of the river to Maori, particularly because the water from that river is supporting a major hydropower development. So their conclusion was, well, why don't we let the river own itself? And so from a Maori perspective, that recognised the river as a living and indivisible whole. That was important to them. And the Aotearoa New Zealand government basically got away without handing that river back to Maori. The thing that was important to Maori was not necessarily therefore the legal rights and powers. And the legal rights and powers of the river have not been relied on since 2017. So it's now coming on to 6 years since that legislation. They haven't been to court. They haven't tried to use those rights and powers to really push that kind of reform or that change in that adversarial setting. What they have done is to say, this changes the relationship between people and the river. They've relied much more on the idea that the river is a living and indivisible whole, and that the relationship between people and the river is central. So one of the principles in the legislation, which I will not try and say in Māori because my pronunciation is appalling, it means I am the river and the river is me. So it's that personal connection between people and the river. And Gerard Albert, the lead negotiator in this treaty dispute settlement for Wanganui iwi, talks about this as long-term generational change. In about 20 years' time, there's going to be significant decisions being made on the future of that hydropower. There's going to be a relicensing process. And so his goal is to have those decisions being made under very different circumstances and by people who have a very different relationship with the river than what they do right now. And one of the reasons, interestingly, that the Wanganui River does not include the rights to water is because Māori, fearing that they would lose a negotiation on those water rights, predominantly because of the hydropower, have chosen to withhold that negotiation. So that's a negotiation they can enter into at any time in the future. They're hoping to create a better circumstance for that to happen. So those are the kinds of impacts and outcomes that we can actually see on the ground. But I also think it's important to pay attention to the broader impacts and outcomes as well, particularly the unexpected outcomes. So when we create river persons with significant new powers, even the ability to have new powers, we can start to see a bit of a backlash, and we start to see what I call the paradox of legal rights. So environmental protection formally goes up when rivers gain legal powers. They can start to take more action to protect their own rights and interests, although we've just seen how some of that is still quite limited in the space of water law. But people are less likely to want to protect those rivers, and that's for two reasons. Firstly, the rivers now have the power to protect themselves. When they're legal persons or legal subjects, they've got the powers, and so people become complacent. They start saying, well, it's not really my job, it was always a bit hard, I never really knew what to do anyway, and now I don't have to do it because the river can look after itself, so I can disengage. That's a pretty terrible thing. That really severs connections between people in place. The second thing that happens, and this is what we saw happen in the case of Drew's Farm and the Lake Erie Bill of Rights, is that people become afraid. They look at this river or this lake with these new legal powers and they see them as a weapon pointed at them. And so they respond with anger and fear and seek to reduce those powers and rights, take them away again before the river can take action. Fear and complacency. This is the backlash or the trade-off between increasing rights and powers. So if you go after a really powerful form of river personhood, the response, the unexpected response, can be fear and complacency, which can ultimately mean either less action to protect rivers or less power for those river persons because they can be stripped of it again. So this is my final slide. When we think about rivers as legal or living persons, one of the things we need to ask ourselves is, are we looking to integrate this with water law, or are we seeking to challenge the very foundations of water law? So recognising rivers as persons is potentially transformative for our relationship with rivers and our legal frameworks, right? It changes the nature of water from a resource over which we might have dominion, over which we are enabled and allowed to exploit. In fact, you could even argue that there's a moral driver in many societies to exploit rivers for the betterment of that society. And changing the river into a living entity with whom we are in a relationship of reciprocity, of interdependence, of obligation. There's an ethic of care that starts to come through in these new relationships. So it is potentially transformative if we focus on that relationship. And that is a challenge to water law and the way we manage rivers currently. It's a powerful way to change the conversation. So instead of, again, focusing on exploitation, what do we want from the river? How much can we take from the river? What does the river do for us? We start saying, what do we want for the river? And how do we get there with the river? The river becomes a partner and a collaborator in its own management. That can be powerful. Of course, it needs then to be integrated with water law for that partnership to take full force and effect, for it to be meaningful on the ground for the river. And without rights to water, which requires integration with water law, and without a role in water management, force and effect of river persons is ultimately very limited. And now I'm going to stop sharing, and I hope we've got some questions coming through. Otherwise, I'll just, keep talking.
Thank you very, very much, Erin. Thank you for that really informative and inspiring presentation. Got loads of questions here, and I'm still sorting through them. But perhaps I'll use my chair's prerogative to ask the first question, if I may. So yeah, I think that it's really interesting that rivers, by having their own rights, being subjects of the law, they can speak finally for environmental hard cause to them, because normally environmental law, water law examines harm through impacts on humans. So how harm is experienced by humans. But by being a legal subject, a legal person, harm doesn't have to be viewed through a human perspective. So to what extent can legal personhood of rivers elevate protection of the environment of rivers? And do we see this being spread in jurisdictions other than the ones that you discussed?
So I think the short answer is that it does enable the court to see the harm to the rivers very directly. So part of this is a question of standing. And so in many jurisdictions now, we've got much wider standing laws than there were, say, in the 1970s when Christopher Stone was originally making this argument. And his argument then was that the courts couldn't see the impact to the rivers unless it had an impact to humans. So the impacts to the ecology, the impacts to the overall system would not be taken into account by the court. So the court was always underdoing the damage assessments because it couldn't see these impacts. So that's one thing that has changed, I think, in the 50 years since Stone. Standing laws are wider. Peak bodies, environmental groups, community groups can now start to bring cases under certain pieces of legislation, so not every piece of legislation, that are grounded in the impacts to the river, but they're still through the lens of the impacts to that community group and that ability of that community group to actually articulate what those impacts actually are. So to a certain extent, it's still being underdone and it's still being seen through the lens of human impacts. It does take a very careful construction of a guardian to enable them to actually identify and articulate what those impacts are to the river as a whole. And it's more than just the ecosystem. It requires an enduring relationship, an intimacy between people and the river to really understand what those impacts are, what the interests of the river are, and how to bring those in front of a court. So some work that I did with some colleagues probably a year or so ago now in the Griffith Law Review looks at the idea of relational personhood and how you can use that as a way of identifying who can be an effective guardian for a river and the sources of information that they might need to draw on to actually bring those interests in front of the court.
Yeah, so that's very interesting. So yeah, are there alternatives, alternative concepts, arrangements whereby there can be humans jointly enforcing this kind of a relationship arrangement between rivers and humans as guardians and so forth, other than legal rivers as a legal person as a concept?
So I think if you're looking at the ability to go to court, that's where legal personhood becomes the crucial kind of linchpin for that conversation. But it doesn't have to be limited to a legal person. And I think that's where the Wanganui is shaping up to be really interesting. It's got those legal personhood powers. So if it needed to go to court, it has that ability. But it's predominantly about the river as this living and indivisible whole and the relationship between the river and the people. That's what they'd be depending on if they ended up in court. So it's, yeah, if I look at the Birrarung Council, for instance, we've spent a lot of time trying to make sure and to put processes in place to think about how we are giving effect to the voice of the river. How do we know what the river wants? How do we know what it needs? And part of that comes through partnership with traditional owners who are also mandated members of the Birrarung Council. But we don't have those legal powers. So if we were going to ever rely on those, we'd have to look at, do we rise to the level of having standing as a peak body or as another group under a specific piece of environmental legislation?
So in which case, do you feel that perhaps there should be more laws and regulations to try to create that kind of partnership, to try to enable the law to see that kind of relationship arrangement between the people and the river? What kind of arrangement or institutional arrangement is required to sort of shift the kinds of attention needed to protect the rivers?
So I think I do. For me, this is the most exciting and potentially transformative part of river persons. I think legally, a lot of attention has been paid to the legal person, but so often relying on those legal powers, Ecuador aside, it's very difficult to make headway and to do that in a way that doesn't result in that kind of backlash where people then just start walking away from their relationships with the river. So I think the way into this, and it's one of the things that kind of learning, we should not be afraid of things that look like mere symbolism, because it is so often the progenitor of hope and extraordinary change. Recognizing a river as a living entity, a landscape as a living being with whom we can be in a relationship is such a big idea. It takes people a long time to get their heads around it, and it starts to change things from the ground up. And I think that's what we're seeing in Te Aotearoa, and I think that's what we're seeing with the Birrarung.
Yeah, I mean that's why these stories are truly inspiring. I mean, and to see the progress that's being made in certain communities and jurisdictions, which are sort of taking the environment as a legal subject and to try to enforce those rights for the purposes of protection of the river. But I'm just wondering, what is needed for places in other places, other jurisdictions, whereby it's that kind of progress has not quite reached, and what needs to be done to sort of bring the focus to having the environment as a legal subject. Do we in your book you basically talked about the role of environmental water managers? Can they play a role? Can basically water markets play a role to raise the agenda and to bring the focus back to river protection?
That's a really good question. And I think there are almost two quite distinct pathways into that. So one is to say, how can we use the mechanisms of water law? And water law, where it creates legal rights to water, where those can be traded, where those can be owned by people for kind of almost any purpose, then that can create a way to establish, either through an NGO or through a government organisation. So the environmental water managers that I was looking at in Australia and the United States are a combination of non-government and government entities. And they use existing mechanisms of personhood. So they would be basically a statutory corporation or a state-owned corporation or a not-for-profit corporation, and they would use that legal personhood to affect change. And they could, in that way, become a kind of proxy person for the river. So not a direct form of personhood for the river, but a way to insert agency and personhood on behalf of the river environment. So they can be a stepping stone. And that's kind of one way into that, is to use existing mechanisms of personhood, find ways that don't require significant law reform, and use those as leverage points to really get your way into that conversation. The other way in is to think about it through the lens of the living entity. And like one of the things that I did in that presentation was to really say, look, local law can be really difficult to get right. But one of the things that it can do, it's quite easy to reform. You can use it to say, let's develop laws that emanate from the relationship between people and place, that reflect the relationship communities want to have with their rivers, and that therefore start to build momentum for change. So it's probably no good to create local laws that try and set you up to challenge state or federal laws, because they'll be struck down. But you could create local laws that recognise rivers or lakes as living entities, and then use that to drive transformative change. So two very different pathways into that creation.
And I've got this great question. Other than the proposed right to flow, which could be equated to the subsidence of the river and thus a right to live in a natural person, what should a river be entitled to for its own interest? Are we satisfied with causing no harm, no pollution? What additional resources we should give rivers for it to thrive? Have we agreed that the right to flow, mainly because of the sustainability idea now, is more acceptable? It's more acceptable globally, but at the end of the day, it's valued only with reference to utility offers to humans. So how do we decide what a river needs? Who decides?
Yeah, that's like when you have to articulate those rights, I think that's where it gets really challenging. So the right to flow often, there's been a few natural entities that have started to receive these sorts of global declarations. So there's a draft declaration of the rights of rivers, there's a draft declaration of the rights of wetlands, And it includes things like the right to evolve naturally, the right to thrive, the right to flow, the right to flow is often defined as water of sufficient quantity and quality to maintain river processes. So it is starting to step into that water law space of saying you actually need to allocate water to the river. So of course, many countries have been experimenting with that with environmental flows for a long time, mostly really underdoing them. So I can't think of anywhere that's really allocated sufficient environmental water to really uphold the ecosystem health of a river. And the right to flow starts to say, if we look at the case of Ecuador, where they're seeing rights of nature extend beyond the requirements of environmental protection legislation, the right to flow could push that to say it's not enough to give it some water. You've actually got to give it enough water so that it can survive and thrive. And that's a really untested area of law at the moment, what that actually looks like and how you get there. That's a big challenge.
And just one final question. Water markets, is the market more efficient than policymakers to address the broader impacts of protecting the water environment, since water is conceptualized as a commodity, it's a property right. So in terms of farming and irrigation, the market will lean towards less water intensive farming, selecting crops that require less water, or ensuring that water rights purchased are free of toxins and chemicals. And so having water saving measures in farming and irrigation and addressing water contamination issues, which are normally the challenges of water authorities, would markets be better at addressing those?
So, yeah, that's a really excellent question. The way I respond to that question is to, instead of posing markets as an alternative to regulation, markets are a form of regulation. And the only way they deliver benefits and efficiency dividends in water management is when they are the servant of water governance and community developed, politically developed objectives for the way that water should be regulated for the betterment of the community, whatever they are, right? I think that's an ongoing conversation in every jurisdiction about how do we manage water sustainably so that we're getting the maximum benefit from it. But markets should only ever be a servant of that overall goal. They require so much investment from the state to establish and maintain. There are informal markets in many parts of the world for water, but their ability to scale up, their ability to have those kinds of quality controls that you're talking about there, particularly when water is significantly scarce, that relies on state investment and state support for property rights and for enforcement, for quality control. So the ability of markets to deliver efficient outcomes, it's a really open question. If we look at, for instance, the experience of Australia in the Millennium Drought, so if we go back to sort of 2007, 2010 in the Murray-Darling Basin, water markets got underway in the sort of mid-2000s, but it wasn't until 2007 that they really spiked in terms of trade. For that 3-year period, water markets meant that overall production in the basin was pretty close to normal in terms of financial output, despite the fact that for those 4 years, water availability plummeted by about 60%. So water markets were tremendously valuable. But one of the reasons they were able to do that is because there was enormous diversity in the way that water was used. Particularly, there was historical investment in water for annual crops like rice, as well as a mix of permanent crops like orchards and vineyards. So during a drought, annual croppers can go, right, you can pay me, I won't use my water, I'll put it on the market and it can go to permanent crops. And then they, of course, can maintain the life of those crops. They don't have to kill the trees or kill the vines, and economic output continues. Since then, the price of water in Australia has been such that it has pushed development of really high return permanent crops like pistachios and almonds. The quantity of water that they require now would take up all of the water that was available on average in those years during the drought. So instead of a system that has flexibility built in, that enables water to move to its highest value use during times of scarcity, you've now got an increased number of people who all desperately need that water. So the ability of the water market to deliver an outcome that maintains productivity is severely reduced. The next drought in the Murray-Darling Basin is going to show that the impacts will be enormous. There will be industries that will significantly be affected. Overall productivity will decline because there has been this strong market signal to put water to its highest value use, but it's lost diversity in the system. So yeah, markets are a complicated thing, and they require constant attention and monitoring to see what signals are they actually sending, and are those signals leading to an outcome that will enable us to get through the next drought or not. So nobody likes to pick winners. Governments are really bad at it. You know, if governments were in charge of irrigation, then that's not a great outcome either. But the thing that the market may not protect is that diversity, and that's what you need.
So thank you very, very much, Erin. Thank you so much for that fascinating, engaging presentation. And I think that it's given us a lot of food for thought and inspiration to engage with water issues going forward. So I'd like to thank everyone for attending today's seminar. A special thanks to Dr. O'Donnell for giving us such an inspiring talk.